Hello, everyone. For those of us who share the same passion for both football and the application of EU law on sports, probably 2024 is a great year. After the Super League judgment, the European Court of Justice delivered another judgment on a sports case, this time on FIFA versus La Diarra. And we are here today with Emeritus Professor of Law at King's College London, Richard Whish, to discuss this case. So what's the case about? In a few words, Lassana Diarra used to be a professional footballer. He signed the contract for 4 years in 2013 with Lokomotiv Moscow, and the year after, in 2014, he decided to unilaterally terminate this contract. So Richard, which of FIFA's rules applicable in this case, and how were the questions for the European Court of Justice framed?
Sure. Okay. So, as you say, we're talking about Diarra, and he's signed by Lokomotiv Moscow. And then there's a dispute between them, and he is found to have been in breach. And then this goes to an arbitral tribunal that decides he's in breach and he has to pay compensation to Lokomotiv. And what then kicks in is FIFA's regulations on the status and transfer of players. And under these regulations, I think it's Article 17, say that there are basically 3 ways in which a player can leave a club without there being a breach of contract. One is when the contract expires, obviously. Secondly, if it's done by agreement. And thirdly, if there is some other just cause. And then the point here is there's no other just cause, so he has been in breach. There is this compensation award. He has got to pay the club. And then the way the rules work is that he can't go and play for another club until this dispute has been settled and the compensation has been paid. Furthermore, if another club signs him, the club becomes jointly and severally liable for the debt that he owes to the previous club. Furthermore, the new club is subject to various sanctions, which seriously inhibits its ability to sign other players. And there's another rule that says that the Football Federation in the original club, which here is the Russian Football Federation, has to issue an international transfer certificate, and until that has been done, the new club can't take him on. So now there's a dispute, which of course goes on for a long, long time, and Diarra's complaint is, I have been deprived of my livelihood, and I could have been earning an awful lot of money, but because of FIFA's rules, I haven't been able to do so, and so I want compensation. And this ends up in a court of appeal in Mons in Belgium, and it says to the Court of Justice, help here, we need some help. How does this fit in with the rules in the Treaty on Free Movement of Persons, Article 45, and how does this fit in with Article 101, on agreements that have the object or effect of preventing, restricting, or distorting competition?
Exactly. And in cases like this, the first step that the court most of the time needs to take and needs to consider is whether actually these provisions of EU competition law and of the free movement are applicable on the rules of FIFA, on this scheme of FIFA in question.
Yes.
So
yeah.
Where did the court land?
Yes, well, I suppose the answer to that is the court landed where it's been landing since 1974. I mean, this is a perennial question. Is sport covered by the treaty? And we can go back to 1974 for the first judgment on this, Koch, and then there was Bosman, famous Bosman, 1995, Deliège in 2000. And basically, where the court has systematically come out is that there are some rules associated with sport which are simply the rules that enable that sport to function. And so FIFA, for example, will have rules saying who can play for a national football team. Well, surprisingly, it has to be a national of that country. And you can't pick a player from Ruritania or Valhalla to play for a particular nation. And so there are rules on that. Well, that's outside competition law and EU law. And the IOC can have rules about which athletes are allowed to participate in the 100 metres and the 200 metres. Those are the rules of the sport. But once you're outside that very narrow area, and basically, let's put it this way, once you're into something that involves directly or indirectly economic activity, then the treaty is engaged. And so 45.101 can apply. There's a little sideshow to that, which is Article 165 of the treaty, that says a little bit about the specificity of sport and its cultural and social importance. But Article 165 does not detract from what I've said, that insofar as we're talking about something that involves economic activity, EU law is engaged.
So competition, EU law is applicable, EU competition law and the free movement. And let's start a little bit with Article 45, which is relevant to the free movement of workers within the union. So the court actually considered this case and considered FIFA's transfer scheme under these rules. And long story short, the conclusion was that those FIFA's provisions are actually disproportionate restrictions of the free movement of worker within the European Union. Richard, would you like to give us a little bit more details on the court's reasoning?
Well, yes. So Article 45, one of the fundamental provisions of the treaty, that the single market, of course, requires free movement of goods, services, persons, and capital. And if you think about rules like this, that clearly inhibit transfers, whether it's appropriate or not to inhibit transfers, clearly transfers are inhibited. So you've got a bunch of footballers in Italy that would like to go and play in Spain, or a bunch of players in Spain that would like to go and play in France. Obviously, these restrictions, these rules can restrict the ability of those players. So it's not difficult to see how Article 45 is engaged. What is interesting, however, because we'll come on to the competition rules in a moment, is whether there are any circumstances in which it is possible to justify measures that restrict free movement. And here, FIFA will argue, well, we have to have some rules about transfers because it's necessary to maintain some sort of contractual stability. Once the season is underway, you want to know who plays for Real Madrid and who plays for Inter Milan. And so you have to have some rules, and I don't think anyone could possibly dispute that. So then the question becomes, can you justify these rules? And the answer is, under free movement of law, if there is some legitimate interest protected by the rules, then they can be allowed, provided they are not disproportionate. Now, you're right that the language of the court suggests that these rules are disproportionate, but let's not forget it's for the national court to which the case returns to actually make a decision on the facts. But the court does acknowledge that there is the possibility of defending these rules. And I say that because of the different position under competition law, which we'll obviously come on to in a moment.
Eventually, the court decided also to go one step further and considered FIFA's scheme under another set of provisions of EU law, which is the provision of Article 101 that, amongst others, prohibits certain decisions of associations of undertakings, like FIFA, which restrict competition within the union by object. So, Richard, why did the court decide that FIFA's transfer rules and the rules on unilateral contract termination actually are anti-competitive?
Well, okay, so what about Article 101? Can Article 101 be engaged here? Clearly, FIFA is an association of undertakings. The rules are a decision by an association of undertakings. Do the rules harm competition? And what the court says here is, you look at these rules, and let's remember, by the way, that if there's a contractual dispute between Lokomotiv and Diarra, and he's in breach of contract, then under the law of contract, he's got to pay them damages anyway. But then over and above the position in contract law, you've got all this additional stuff, and he can't play anywhere else, and you can't get an international transfer certificate, etc. And there's no transparency around these rules. There are no criteria laid down as to how they're to be exercised. And the court is clearly of the view, though I repeat, ultimately it's for the Belgian court to decide on the facts, but clearly the Court of Justice thinks that these rules are disproportionate and as such have the object of restricting competition. And what is interesting in the judgment is that it does equate these rules to being a no-poach agreement, because competition authorities everywhere have been interested in labour markets, wage fixing, no-poach agreements. And now we find in these football cases the court saying, well, this is like a no-poach arrangement. Paragraph 145 says, under the guise of preventing aggressive recruitment practices, these rules correspond in fact to non-poaching agreements between clubs, which in essence result in artificially partitioning the national and local markets to the benefit of all clubs. Very interesting. No poach. Then you come on to the question of justification. I've said under Article 45, you can try to say, well, this is necessary to maintain contractual stability and so on and so forth. There's kind of a legitimate interest defence. But the court here says, if you're dealing with an object restriction, then the Wouters defence of competition law, you've got a restriction, it pursues a legitimate public interest, that can therefore be justified if it's not disproportionate, and the court says here you can't apply Wouters to an object restriction, which of course they had said earlier in the European Super League case. So I find this as a matter of law very odd. These rules might be justifiable, but you can run that argument under Article 45, but you can't run that argument under Article 101. I don't get that. Feels to me wrong, but if the European Super League judgment, a chamber of 13 judges as a grand chamber say it, it can't be wrong. It just has to be something I disagree with, but it seems a very odd outcome to me.
The reasons leading to the conclusion might not be exactly straightforward, but that conclusion is clear and uncontroversial that, FIFA's transfer rules are in breach of EU law. And of course, there is some room for the national courts to decide upon the facts. But looking at the broader image here, so this judgment, a lot of people say, will shift economic power towards players even more than before, and might have a material impact on FIFA's transfer system, or might not. So what do you think, Richard? What do you think the impact will be in the future?
I do not know, is the answer to that. I'm always hesitant when these sort of fascinating new judgments come out. I'm hesitant about making broad, bold conclusions. Let us wait and see. The pyramid of football, the financing of football, how the profits are divvied up between clubs and players and, and agents, very complicated stuff. This does change things, absolutely clearly. I think it does put more power on the footballing side, the footballers' side of the market. And FIFA and UEFA are going to have to respond accordingly. But does it lead to a massive revolution in the whole system? Well, let's wait and see.
It'll be also interesting to see how eventually the balance between the stronger clubs and the less stronger clubs within the EU is going to shift following this judgment and following the increased power of players and managers to actually move between and among clubs. Richard, thank you so much for your time and for this discussion about football and the law.
Pleasure.